SJC-12590, Christian Miranda v. Suffolk Superior Court.
Mr. Schubert, good morning.
The last case.
Good morning. May it please the court, this is obviously the second time that I'm back before this court on the Miranda matter. I point out that in my 42 years that I've practiced before this court, the last time I was before this court, it certainly seemed that the court was not buying my argument that I had a right to intervene in the matter. And the court sent me off with instructions to file in the original case my MNT and my motions for discovery. I did that. I followed everything that this court ordered me to do. Within 10 days, I had an opposition from the government, and within a month, I have a denial by the RAJ. I filed a writ of certiorari under 249-4, and I'm back before you again. My brother keeps claiming that I really have no rights to file a 249-4. My MNT is not a viable MNT. We know, and the one thing that's absolutely clear, there is not one member of this court that believes anything in Judge Carey's decision other than the fact that Justice Kinder was lied to. There were no rogue assistant attorney generals. There were Enterprise and Major Crimes Unit officers who perpetrated a fraud. This court has used the words egregious, horrifying, terrible. We've watched the court move along. Farrak isn't over with yet. And if I get to say one thing on behalf of Mr. Miranda, it isn't just the drug cases that are affected by the Farrak matter. It's people on the periphery, like Christian Miranda. How is he supposed to show at this point in time that the people that applied and signed the affidavits for search warrants and wiretaps were some of the biggest liars employed by the Commonwealth of Massachusetts, who are supposed to be officers of the court and justice? There's been no justice here. And if I'm not allowed to have an MNT, and we know, another thing that we do know, any member of this court believes that they're going to allow anyone to find out who actually got all of the emails and who knew what. But if we believe for even a second that two rogue attorney generals were responsible for this, two people who have moved on to better paying jobs that they don't even need to be lawyers, that we were able to effectuate this without Martha Coakley or Mara Healy knowing anything about this? That's sheer fantasy. And what are the people supposed to do that are affected on the periphery? They are affected. Is not the jury entitled to know when an officer testifies relative to the affidavits in which they filed that these men are not always truthful? And remember, they didn't just hide that from us, the defense bar. They hid it. They hid it from the district attorneys who were supposed to prosecute. My brother keeps saying I have no rights to go under a 249-4. Well, the one thing that we do know, and I've practiced before this court long enough to know, this is no 211-3 because there's nobody about to die. And basically, it's amazing that the Committee for Public Counsel Services were able to entertain a 211-3 in the Farrak matter rather than a 249-4. That aside, so if in fact I can't file a 211-3, if I can't file a writ of certiorari, if I can't get the evidence to validate my motion for new trial, then is that not stripping Christian Miranda of his rights to due process under law? This court cannot keep saying that the conduct is egregious and not give people that are on the periphery that are not drug cases some ability to utilize what we now all know really did happen. And it continues to happen. So what does Christian Miranda have as an option? I tried to intervene. I got shot down. I filed my MNTs originally. I got shot down. I came here on a 249-4. I got shot down. And it's not me that gets shot down. It's Christian Miranda. And then I go back and I follow everything that this court ordered me to do. Everything. And Christian Miranda got shut down again. Because they're never going to tell what they actually know. And these are perilous times. Perilous times when the judiciary has to take some action to rein in the executive branch, which is in this case, the Office of the Attorney General. There isn't one of us here that has any doubt about what really happened and who knew what. And this conduct, it is certainly the law, at least as a trial practitioner and as an appellate lawyer. The trier of fact is entitled to know about the person who's giving them testimony. It's not just the cute badge. It's the fact that we know that in an instance where Martha Coakley, this is how many televised conferences she had relative to Christian Miranda. We said the Magnolia Steelers will start Operation 1370, the temperature at which steel melts. I want this person. I want him because he's a very bad person. He is a criminal. Are we not to assume that if the Enterprise and Major Crimes Unit can lie about what happened in Farak, that same lies and same understanding about what's going on at the top isn't supported by the officers who support that office? So what is Christian Miranda supposed to do? I read my brother's brief. I'm sure you did too. I just don't understand what options he has other than getting a motion for new trial.
How about moving to appeal the denial of post-conviction discovery?
That's
Or the appeals court?
And the chances of that, Judge, are statistically basically non-existent. I really believe that if I've done anything right...
Avenue of appeal pursuant to certiorari only because you think you're not likely to prevail on the avenue of appeal provided to you by our procedures.
Well, I would admit to the fact that that's exactly the course that I took. And I took it because I believe from the very, very beginning that we needed to explore something in the examination and the evidentiary hearing that would have exposed the conduct much earlier and not even allowed for the decision that Justice Carey made. Last time I argued before this court, I'm a Hampden County practitioner in capital cases, and I know Judge Carey well. He's a man of honor, and the answer is, what he wrote, though, does not comport with what the facts that we all know.
Where in the record are the facts that we all know?
The record is that Farak and Dukin received sentences and treatment that was preferential, and it could not possibly have been two rogue assistant attorney generals that came to the conclusions and lied to the court. Somebody had to know up the chain, and that's why we know that Judge Carey's decision is wrong. It's wrong because the police hid it from the district attorneys. They hid it from everyone, but they certainly didn't hide it from the attorney general or the assistant attorney general or the people up the chain. And there was no one, I argue to you, at the evidentiary hearing, which is the reason that I applied to intervene, who actually was going to expose that. That's the real problem here. I don't think anybody in this court can deny the fact that there are people on the periphery that are impacted, and they are not drug cases. So I just say to you that we all know that they are never going to give me anything about the emails that would prove who knew what and when. But it is essential for me in my motion for new trial to get that information, because why do they keep denying me my motion for new trial? They deny it because they say you can't prove who knew what. Well, I can't find that out unless this court either orders them to, or orders that a person that is on the periphery and affected actually gets the advantage of the fact that he didn't know. It's newly discovered evidence. He had no idea. So I ask you, please allow the motion for new trial, or make the government give me the information that will prove that what I've said is all true. Thank you.
All right, thank you. Mr. Boshin.
Good morning. May it please the court. My name is Thomas Boshin. I represent the Commonwealth in this appeal. When the parties were before the court previously in connection with the petitioner's effort to get post-conviction discovery, the court concluded in part that he should do so with a Rule 30 motion in the context of his own case. That is, in the normal course. That principle still applies here and is alone reason to affirm. But even if the court looks at the merits here, the petitioner has not demonstrated any nexus to the Farrak matter. The drugs were not tested by Farrak. They were not tested at the Amherst laboratory. And there's never been an allegation that either of the two former prosecutors was involved in the case. Unless the court has questions, the Commonwealth is content to rest on its brief.
All right, thank you.
Thank you.